Yes. Okay. Lucille Jones. Okay. Ms. Jones?
Yes, sir.
Nothing but the truth to help you God.
I do.
Thank you, ma'am, and you may proceed, Mr. Means.
Ms. Smith, are you the current CASA volunteer involved with the foster children?
Yes.
And have you heard that?
Where's that coming from?
I got the other court going on, Judge.
Okay.
I muted the volume.
Okay, thank you. Okay, Ms. Jones?
Yes, sir.
Okay. Leslie, you ready?
Yes, thank you.
Okay. We'll go on the record in cause number D40729-CR, State versus Lucille Hardaway Jones. I have counsel for both sides present, defendants present. Ms. Jones, is that your full and complete name?
Yes, sir.
Ms. Jones, you are charged with the offense of unauthorized use of a motor vehicle, and it's the court's understanding that you're wishing to enter a plea of guilty to the offense alleged in the indictment. Is that correct?
Yes, sir.
And do you understand, ma'am, what you're pleading guilty to?
Yes, sir.
And Mr. Keithley, do you wish to waive a reading of the indictment?
Yes, sir.
Record can so reflect. Now, it's also my understanding that there's an enhancement paragraph or enhancement paragraphs, and those are being abandoned. Is that correct?
Yes, Your Honor.
Okay. And so, Mr. Keithley, I'm going to, and Ms. Schumer, I'm going to scratch through on the face of the charging instrument, the language, the enhancement paragraph language. Okay?
Yes, sir. No objection. Wait 10 days.
Okay. I apologize, Your Honor. I did this judgment myself, and so I just typed abandoned in there, and that might not be the right thing.
No, that's fine either way, but we'll get it taken care of at both ends. Okay. And so, Ms. Jones, I do have documents that appear to have your signature on them. They are written waivers, written plea admonishments, a waiver of your right of appeal, a judicial confession, and an evidence discovery log. Did you sign these documents?
Yes, sir.
Did you understand these documents?
Yes, sir.
And your attorney went over them with you, is that correct?
Yes, sir.
Ms. Jones, you understand you have a right in this case to have a jury trial, and you're waiving that right.
Yes, sir.
And you understand you also have a right to have that same jury assess punishment should you have been found guilty.
Yes, sir.
All right. Are you a citizen of the United States?
Yes, sir.
This is a state jail felony, ma'am. It carries a range of punishment anywhere from 180 days up to 2 years in state jail and a fine not to exceed $10,000. Do you understand the range?
Yes, sir.
It's the court's understanding that you have entered into a plea agreement with the state through your attorney. Is that correct?
Yes, sir.
Now, the court will not agree to be bound by the plea agreement. However, the court follows the plea agreement. It cuts off your right of appeal except by permission of the court. You understand that?
Yes, sir.
Are you entering your plea of guilty freely and voluntarily?
Yes, sir.
And do you understand the consequences of your plea of guilty?
Yes, sir.
Your attorney is Mr. Keithley. Are you satisfied with his representation in this case?
Yes, sir.
And Mr. Keithley, your client certainly appears to be sane and mentally competent. Is there anything your client has said or done that would cause you to believe otherwise?
No, Your Honor.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered her plea of guilty, that she understands the consequences of her plea of guilty. The court will accept that plea of guilty and find the defendant guilty should the evidence prove her guilty. I have in front of me states one, a judicial confession signed by the defendant. States he can have that exhibit admitted.
Yes, Your Honor.
No objection.
It's admitted. Anything further from either side?
No, Your Honor.
No, sir.
State have recommendation?
The state's recommendation is 12 months state jail, $210 fine, $290 court costs, and 130 days time credit served.
How many days? 130?
130, yes, sir.
Okay. And Mr. Keithley, is that you and your client's understanding?
It is.
Okay, ma'am, based on the evidence, the court will find you guilty of the offense alleged in the indictment. It's the judgment of the court. You're sentenced to 12 months in a state jail facility. Court costs and a fine are assessed. Any reason why sentence should not be pronounced?
No, sir.
Ma'am, you are sentenced to 12 months in a state jail facility. You'll be remanded in the custody of sheriff, who will transport you to the appropriate facility, begin serving out the sentence. This sentence begins today. You are given credit on the sentence, ma'am, of 130 days. And any day thereafter, you're awaiting transport. Furthermore, the court will make a finding at this time you are presumptively entitled to receive diligent participation credit if and when that's received by the court. Do you understand?
Yes, sir.
All right, ma'am. Do you have any other cases pending?
What is it, Mr. Keithley?
It's a credit
Financial.
card. There's a financial case that's a misdemeanor, Your Honor, and I'm not sure if I've been appointed on that yet, but I'll be working to clear that up as well.
Okay. All right, ma'am. Did you have something you wanted to ask?
Yes, sir, because I was in jail when that was done to me. I was here
Okay. What are you
when
talking?
whoever did
She's referring to the
the
misdemeanor
credit
case,
card
Your Honor.
abuse.
Oh, okay. Yeah, that's not something I have that I'll be presiding over, ma'am. So you'll need to speak to your attorney about that, okay?
Okay.
All right.
Will I get the 80/20?
Yes, ma'am. I've just made that finding that you are presumptively entitled to receive that, okay?
Yes, sir. Yes, sir.
All right.
Thank you.
All right. In this case, ma'am, you've waived your right of appeal. That concludes this hearing. The bailiff will come over here shortly and get your print on the judgment on the docket sheet, okay, ma'am?
Yes, sir.
Good luck to you, ma'am.
Yes, sir. Thank y'all and have a blessed day. Thank you, Mr. Keithley. God bless.
Hey, Ms. Jones, you too. I'll see you in a little bit.
Mr. Barnson? Okay, this is cause number D40519-CR State versus Christopher Blaine Barnson. I have counsel for both sides present. Defendant is present. And this is a motion to continue filed by the defense, I believe. And Mr. Keithley, you may proceed.
Your Honor, I'll let the motion speak for itself. I was informed by Mr. Aguilar, who appeared on my behalf at trial announcement the other day, that the court had requested that I file a motion for continuance in consideration of my request not to have it put on the trial. Therefore, I followed up with this motion for continuance for one more setting before trial announcement.
Okay. State have any position on the continuance?
I do, Your Honor. If the basis of the continuance is that we're trying to work out a plea, I'd suggest to the court that pleas are worked out a lot more quickly when there's a trial pending than they are if we kick the can down the road another month or two. So with that in mind, if we get it worked out, then by all means, we'll contact the coordinator, we'll get a plea date. But otherwise, I think this is the only case left on the June docket.
Well, I wish that were the case. It's not. There's a lot of civil cases and CPS, but as far as criminal, yes, that is correct. That is the only one left. I can take this under advisement, and Mr. Barnson is not in custody. And then what I need to do is I also want to look at what's left. I know there is at least one CPS case, and I want to see where we are on that one. Okay.
Yes, sir.
Yes, sir.
All right. That concludes this hearing. Thank y'all.
May we all be excused, Your Honor?
Yes.
Thank you.
I have an arraignment to do on, magistration on Mr. Williams Stevens. Is the jail still there?
I think he said Dalen. Judge, did you say Stevens?
No, yeah, Dylan Stevens.
Yeah.
Your Honor, do you want state present for magistration?
No, you don't have to. Unless
Are
you're
you
just
excused?
curious. Yes, sir.
Thank you, Judge.
Have a good day.
You too.
Mr. Stevens, is it?
Yes, sir.
Cause this is the last room, that one out. I can use this one.
Give me 1 second.
Based on the fathers, if they produce anything for you, make a demonstration of that. So,
Mr. Hayden.
So you got tested other issues that I was there. How long has you been there? What was your last deal? Well, you drug use is a fair amount of testing for drug use since you've been over this.
On March 25th.
Okay. Give me 1 second, Mr. Stevens.
Yeah, I've been looking for her and I've left messages at the residence she's living at and with her mother.
No further questions, this witness, Judge. I'll call my next witness, Melinda Beltman.
Will you please raise your right hand? Do you swear to be the testimony you're about to give in the case? Yes, here with both, Gabby and, we're concerned that it would follow, we have a similar developmental process like. When he seems to jam out that, a person never knows.
Do what? Okay. Yeah, yeah. Okay, Mr. Stevens, is that your full and complete name, Dylan Stevens?
Yes, sir.
there's any opportunity to return the child to this time.
I do not.
Mr. Stevens, my name is James Loggemer. I'm the district judge here in Navarro County. I'm going to go ahead and magistrate you at this time. You understand you're charged in this offense, which is D41028, with a 2-count indictment of aggravated sexual assault of a child. Do you understand what you're charged with?
2 counts?
2 counts, yes, sir. Do you understand what you're charged with, sir?
Yes, sir.
You understand, sir, that you have a right to retain counsel and to have your attorney present during any interview with peace officers or attorneys representing the state. If you're indigent and cannot afford counsel, you have the right to request the appointment of counsel. Do you understand that?
Yes, sir.
You have the right to end any interview or questioning at any time. Do you understand that, sir?
Yes, sir.
You have the right to remain silent. Do you understand that?
Yes, sir.
You're not required to make any statement, but any statement you make can and may be used against you in a court proceeding. Do you understand that?
Yes, sir.
And finally, sir, you have the right to have an examining trial if charged with a felony. Do you understand that right?
Yes, sir.
All right. You do have a time to speak to counsel, sir. Do you have an attorney?
Bill Price.
Bill Price? Okay. And each of these counts, sir, count 1, bond will be set at 51,000 surety. Count 2 will be set at 51,000 surety. With the following conditions: a bond that you not directly communicate with the alleged victim in this case, nor that you go near a residence, school, or any other location frequented by the alleged victim. Do you understand those conditions?
Yes, sir.
What I will do, sir, is I'm going to, first of all, you are seeking the appointment of counsel in this case, is that correct? Which you've already done,
Yes.
Mr. Price.
Yeah. Yes, sir.
Are you a citizen of the United States, sir?
Yes, sir.
Okay, so you don't need to speak to the consulate of another country. I'm going to get you to sign off, sir, on that you understand your rights. The bailiff will come over here in a moment and get you to sign this, and then you'll probably need to speak to Mr. Price, okay? All right, sir. I believe we're done, and she'll come over in a bit, okay? All right. Thank you. I don't know.
Good evening, Judge.
How you doing? I think that's it. I'm sorry.
Yeah, I think so. I got the other court running. I apologize for the noise.
That's okay. I think Shelley will be over there in a little while to get a print on Miss Jones.
Jones and Dylan.
And she's gonna bring over the magistration form on Mr. Stevens as soon as I get done.
Okay.
filling it out.
All right, Judge. Have a good day. We'll see
Thank
you
you.
maybe tomorrow.
Yes, well, maybe so. Have a good
All
day.
righty.
Take care.